All right. Let's talk about Chapter 3. Chapter 3 is going to be medical, legal, and ethical issues. We'll go ahead and dive in. Um, some standard competencies you should know applies to fundamental knowledge of the EMS safety, well-being of an advanced EMT, some medical, legal, and ethical issues to the provision of the emergency. Some stuff we'll be covering is consent, refusal of care, confidentiality, advance directive, tort and criminal actions, um, evidence preservation, and statutory responsibility. Sorry. Some more medical and legal ethics stuff is mandatory reporting, ethical principles, and moral obligations, and end of life issues. So one of the main things we want to do in the pre-hospital environment is try to do no harm to our patients. That's our main goal. We want to be there to help, not to cause further sickness or injury or insult to what has already occurred at that particular time. So, litigation against EMS is likely to increase due to the increased availability and complexity of emergency medical care. As an event, EMT will be governed by a set of laws affecting how you treat your patient. Providing competent emergency medical care that conforms with the standard of care taught to you will help you both avoid civil and criminal action. So you must also consider some ethical issues, ethics or principles, either personal or societal, that determine what is right and what is wrong. So one of the major differences between laws and ethics is that laws have sanctions for violations that are enforceable. So ethics can be something that you particularly believe yourself. However, a law is something that is written in stone. It is on paper. So laws define your obligations to protect your rights and the rights of others. So failure to perform your job can result in civil and criminal liability. All right. Some other things about um, the law is, even though you do render emergency medical care, at times you may be sued by a patient who seeks to obtain release, often in the form of a monetary reward or the loss of income from pain and suffering. You have to think about an administrative piece also. You can be regulated by your state and possibly also by your local EMS system. So a scope of practice outlines the care that you will be able to provide. It usually is defined by state law. Your medical director further defines by developing protocols and standard orders. Your state has a set of protocols that is a generic set, but it kind of gives each county, each local system a guideline to set forth in their local systems themselves. So this is your protocols and what you can do as far as standing orders without having to call for medical direction or online medical direction. So standards of care is a manner in which you are required to act and behave. It can be defined by law, and under given some circumstances, you have a legal duty to act or not. You must be concerned about the safety and welfare of others when your behavior is potential to cause harm. Standards of care is established by published medical research, local customs, how a reasonably prudent person with similar training and experience would act under the similar circumstances. Often based on locally accepted protocols, you will not be held to the same standard of care of physicians or other more highly trained professionals. The prevailing customs of the community, such as determining when EMS helicopters are used or how hospital destinations are selected, are important elements in determining the standard of emergency. Um, so, standards imposed by laws are include statutes, ordinances, administrative regulations, or case law. We are do have statutes as far as our care, as far as emergency medical service in the pre-hospital environment. There is North Carolina general statutes that we have to abide by. Any jurisdictions violating one of these standards is said to be create presumptive negligence. So always you need to be familiar with particular legal standards in your state. The EMTALA was enacted in 1986 to combat the practice of patient dumping. It pays particular attention to when practice of sending women labor to distance hospitals. So patient dumping back before this EMTALA law was brought into effect is basically, you might be sending a patient from a tertiary hospital to a, trauma center that may be completely full already. They may have had some local stuff going on within their own jurisdiction, but basically what you're doing with EMTALA, it helps those receiving patients at maybe that trauma center or a specialty care center. Make sure that the doctors and the nurses there know that this patient is coming. So, also another thing with the EMTALA, if you are doing a transfer in a non-emergency setting and you're doing it from one hospital to another hospital, please make sure that you receive that EMTALA form. It covers, not only you. If you get to that receiving facility and like, no, we don't know nothing about this patient, well, you can look at that EMTALA form and say, hey, this doctor talked to this doctor, is supposed to be receiving this patient, and this nurse talked to this nurse, and they're supposed to be, receiving this patient also. So, professional or institutional standards, the AHA CPR standard is, an example of how that standard is for CPR, chest compressions, chest compression to breath ratio, how it is supposed to be met on a daily, day-to-day basis. So your state regulatory agencies, maybe North Carolina Office of UMass here in North Carolina, different things like that. Standards imposed by textbooks. In virtually all EMS textbooks follow standards established by NETSTA. They often recognized as contributing to the standard of care that is allowed by advanced EMTs. EMS enabling legislation. Most states now have what is called EMS enabling legislation, which defines how EMS is structured and designates responsibilities of government agencies. These laws also provide a state-based framework for the advanced EMT actual practice. So, standards imposed by states. The Medical Malpractice Act was, in some states, EMS personnel are exempt from licensure requirements of the Medical Practice Act because an advanced EMT is regarded as a non-medical professional. So it does define the minimum qualification of those who may perform various health services, defines the skills that each type of practitioner is legally permitted to use, and establishes the means for licensure. So when you are unsure of proper care, contact medical control for orders. question orders that are unclear or seem inappropriate. And do not blindly follow an order that does not make sense to you. And that's why I was saying a little bit ago about the online medical direction. Make sure that you and the provider you're talking to both understand, not only your qualifications, what you can do, um, but your practices also and your scope of practice locally within your system. So certification is the process by which an individual institution or program is evaluated and recognized as meeting certain predetermined standards to ensure safe and ethical practice of care. It generally refers to a certain level of credential based on hours of training and assessment exams and addresses criteria met for a minimum competency. Kind of like the AHA, giving you the CPR cards. So a licensure is the process by which an incompetent authority, usually the state, grants permission to practice a job, trade, or profession. So it's granted by a government authority on certain conditions. It has rights and privileges conferred by licensing in one state, may not be conferred in other states, so you may not be able to go from state to state. You may have to get reciprocity or something like that. So credentialing may be adopted by a specific EMS agency as part of its employment requirement. So to be able to get a job, you may have to actually have a certification or a license, depending on which state you're in, and be able to prove it. The cool thing with the online testing now, a lot of times many people have seen a quicker turnaround as far as being able to see that certification online when you log in through our local continuum system. Some services may also require you to actually have a paper copy too. So when you turn in that application for employment, you may want to print off a copy, and that way they can see it, immediately and not have to look for it later. So negligence, failure to provide the same care that a person with similar training would provide. Okay, a deviation from an extended standard of care that may result in further injury to the patient. Negligence. Okay. So, gross negligence conduct that constitutes a willful and reckless disregard for a duty. There's three categories: malfeasance, nonfeasance, and the thing that speaks for itself. So, malfeasance occurs if you perform an act that you're not authorized to do. So it also covers if you legally are permitted to do an action, but you do it so in an improper manner. Nonfeasance occurs if you fail to perform an act that you're required to or expected to perform. The Latin interpretation of this, the thing that speaks for itself, is under this theory the injury could only have been caused by negligence. So it is kind of rare, but the only time this really does happen is, for example, if you're certified at the advanced PMT level and you do something at a paramedic skill. So, the law does recognize two classifications of a tort. I mean, this is basically a civil lawsuit of wrongful act that you just performed. So unintentional torts, commonly referred to as negligence, and then intentional torts are those that describe an intent to cause harm. The torts are defined as civil wrongs, and they are not within the jurisdiction of the criminal court. So you will be fully. All the four have to be following elements must be present for negligence to apply. So, duty. You have to have an obligation to provide care in a manner that is consistent with the standard of care established by local training and local protocols. So, Responsibility comes from either a statute or a function. A bystander is under no obligation to assist a stranger in distress, therefore has no legal duty to act. Some instances in a legal duty to act, you're dispatched or witness an emergency situation while on duty. The policy of your service or department states that you must assist in any emergency. Once you respond to call, of course, you got a legal duty to act. So the only thing that really a lot of people kind of get in confusion with this about is like if you're off duty, you come up on something. You come up on a wreck or something like that. You're not legally obligated to stop and assist patients. This law does vary from state to state. The Good Samaritan law usually covers a lot of people, but if we're not on duty and we're not advertising ourselves is what I call it. So be familiar with the laws and policies that apply in your service area. Breach of duty occurs when a person accused of negligence failed to act as another person with similar training would have acted under the same or similar circumstances. It may involve doing less than the person who was trained to do, or doing more than the person was trained to do. So, don't go out there and split your eye laceration, or don't go out there and fail to splint an injury in extremity. So, damages, the objective of the civil lawsuit is usually some sort of compensation when a patient is physically or psychologically harmed in some noticeable way. Although physical injury is usually not part of any lawsuit for medical negligence, patients may also claim damages for emotional distress, loss of income, and loss of enjoyment of life. So, proximate cause is a legal term in the sense of medical malpractice. It essentially considers whether the alleged harm to the patient would have occurred but for the negligent act. So if the injury would have still occurred regardless of the alleged act of malpractice, then no valid claim exists. So if you have a legal duty to act and abuse it, causing harm to another individual, then you can be sued for negligence possibly. So you have to have all of these to actually get a complete case against you as far as negligence. Also remember that. So, abandonment is basically termination of care to a patient without a patient's consent. So, once care is started, you have assumed a duty that must not stop until an equally competent person with equal or higher training assumes responsibility. So, you have assumed duty that must not stop until an equally competent person with equal, or higher training assumes responsibility. So, abandonment is a legal and ethical serious matter that can result in civil or criminal liability. Abandonment may take place at a scene, or it could take place in an emergency department. So, legal patients do assume care for at the site of a single car crash to care for the injury for people injured at another site where two cars have crashed. In the ED, you go in there, you drop off your patient. So you give you may give a report to somewhere at a lower care unit, so that's why we always ask you to give reports to registered nurses or providers in the ED. So, you may ask about multiple patient things. You may have resources that come up to you and maybe a little care than you But always remember that you are acting in the part of triage, so you're really not taking complete care of those patients. You're triaging those patients out so that adequate resources can transport those patients. Assault and battery. So assault is threatening or causing a person fear of immediate bodily harm without consent. So for example, you may threaten to start an IV line on a patient using a large needle, or threaten to restrain a patient who does not want to be transported. So battery is unlawful touching of a patient, making physical contact with a patient before asking if you may touch him or her may be considered battery. So that's, sometimes that's why we have to, make sure that patients are clear that we are, we have to touch them, that we have to, feel their arms and feel their legs or different things like that, see if they are injured. So, or, like that trauma patient, I always say, hey, look, we got to cut your pants or your long sleeves or anything, and make sure that you're not injured anywhere else. So, it can be civil or it can be criminal in nature to prosecute criminal charges of assault and battery. So the prosecution generally needs to prove the intent to cause harm. In a civil case, the plaintiff may only establish the conduct took place without his or her consent. Kidnapping or false imprisonment. Seizing, confining, abducting, or carried away by force. This is not common in EMS. False imprisonment may be more likely. So we don't get consent to actually take these patients on the ambulance and take them away, then we could get accused of kidnapping. This comes up a lot. It's not a lot of times you have family says you will take this patient away from here. The patient's constantly oriented, is making their own decisions, does not have a power of attorney, does not have any documentation supporting things. So you have to make sure that they understand also that the patient could sue you later for kidnapping. False imprisonment is unauthorized confinement of a person that lasts for a appreciable period. All right, defamation is intentionally making a false statement through written or verbal communication that injures a person's good name or reputation. Libel is making a false statement in written form that injures a good person's name. So, if you write your PCR, avoid using terms that may be judgmental or are offensive. Okay? Slander is making a false verbal statement that injures a person's good name. So if you're sitting in a restaurant and you, by some unknown reason, say something out loud, if somebody hears you and says, hey, look, they made the statement and they can prove it, they may get you for slander. So good Samaritan law is immunity. If you are reasonably helping another person, you should not be liable for errors and omissions that are made while giving good faith emergency medical care. No, however, they do not protect you from lawsuits. They do vary from state to state. Another group of laws grants immunity from liability to official providers. Sovereign immunity identifies limited types of lawsuits that can be filed against government agencies. EMS personnel work for government agents may have some governmental immunity for their actions. Governmental immunity generally applies only to EMS systems that are operated by municipalities or other government entities. So, if your service is covered by immunity, then it may mean that you cannot be sued at all, or it may limit the amount of monetary judgment that the plaintiff may recover. So, this does significantly vary from state to state. So, a lot of times when you go and you try to sue from a patient standpoint. You're always going to start with the people with the biggest pockets. So you're always going to start with the county in general, and you work your way down to the individuals, by groups, and the agency, maybe the supervisors, and then you get down to the providers themselves. So with governmental immunity or sovereign immunity, that can help as far as being a government. All right, consent. It is permission to treat. It is required from every conscious and mentally competent adult before care can be started. So if the patient is alert, rational, and capable of making informed decisions, he or she has the legal right to refuse care. And this is one of the things that's always hard to make family members understand. Okay? So required decision-making capacity and the ability of the patient to understand the information you are providing and process that information. This is where you have to talk with these patients, find out if the patient understands what's happening to him or her. So you want to make sure they're able to process that information and make an informed decision regarding their care. So you may want to talk to that patient, make sure they understand what's going on around them, see if they know who you are and who you're affiliated with. Maybe there's somebody there that's not, normally there. A lot of times I use like friends or families, or sometimes people from different groups show up. Maybe some next door neighbors that don't always come over, or some people from their local religious institution, different things like that. See if they can point those people out. Law enforcement's there, or fire department, see if they understand what's going on around them. So, express consent is where the patient acknowledges that he or she wants you to provide care or transport. It may be verbal or nonverbal, and the patient must provide informed consent. So, to be able to obtain informed consent, describe the suspected illness or injury to the patient, describe the treatment you would like to administer, and list the potential risks associated with proposed treatment, discussing the alternatives, types of treatment available, and advise the patient regarding any potential consequences of refusing treatment. Okay? The patient must be of legal age, able to make rational decisions, and the patient may agree to certain emergency care but not other care. So, hey, they'll take a ride back in the ambulance. However, they don't want an IV started. Okay? And, you're going to explain, hey, look, if we do this IV, you start having pain, I can give you some type of medication that may help with your pain. Or you start sneezing again. I need to be able to get that medication to you as quick as possible. But they do have the right to refuse that. If they do, we'll talk about that later. You may want to get a refusal sign on that to make sure everybody understands. So the patient must be at least 18 years old, able to make rational decisions. Implied consent is when a person is unresponsible, otherwise unable to make rational and informed decisions about his or her medical care. So the law assumes this patient would agree to medical care and transport. So it's an unresponsive, delusional, exhibiting an altered mental status as a result of drug or alcohol use, or otherwise physically unable to give express consent. Do not rely on express consent. Correction. Do not rely on implied consent unless a threat or to life or limb exists. The principles of implied consent is known as an emergency doctrine. All EMS personnel allow the EMS personnel to act in critical situations without danger or recommendation. So, try to get consent from a spouse or relative before treating a patient based on implied consent. Refusal of emergency care may also be implied, such as the patient pulling her arm away from a splint. If a patient's being treated on implied consent, regains consciousness and appears capable of making an informed decision, then the emergency doctor must apply consent no longer applies, aka, your patient's there with hypoglycemia and you get drugs that, you're D50. Patient becomes alert and oriented and knows what's going on. They have then have to apply express consent to be transported to the hospital. And one of the hardest ones we ever come into, I think, is one of the hardest ones is your opioid patients that you give a drug to and they become alert oriented. They have the right to refuse. So just by, again, try to get consent from a spouse or a relative or somewhere nearby and around that kind of understands what's going on. Minors and consent. So parents or legal guardian must give consent as long as one's present. So in some states, a minor can give consent depending on the age and maturity, and married, pregnant, or emancipated minors. So, if a parent cannot be reached to provide consent, then healthcare providers are allowed to give emergency medical care to a child. Okay, and this just covers us, in all kinds of ways. Minor can give a valid consent to receive emergency medical care depending on the minor's age and maturity level. So, an emancipated minor is a person who, despite their legal age in a given state, can be legally treated as an adult based on certain circumstances. So, they may be married, members of armed services, or parents. They were parents themselves, or living away from or no longer relying on their parents for support. So a court may issue an order declaring that a minor to be emancipated, but such situations, usually uncommon. Obtain consent whenever possible in loco parentis. So in the place of a parent, you may have in a school, daycare, or summer camp if the parents are unavailable. The school administrator or daycare director may take treatment and transportation decisions on behalf of the minor. So try your best to contact the parent or a legal guardian, but however, do not withhold life-saving emergency medical care. Just go ahead and treat that patient, okay? Involuntary consent. Oxymoron, because consent can never be involuntary. People under arrest or in prison do not lose their right to be involved in medical treatment decisions. So, if law enforcement officers to direct EMS personnel to treat a person under arrest, you should continue to follow informed consent guidelines. So, if a prisoner refuses treatment, then you need to involve your medical control. However, if it is a true emergency medical emergency, you can assume that implied consent exists. So, forcible restraints are act of subduing a patient to prevent harm. Applies to patients who are physically violent, present a risk to others, or in need of treatment. So, they're presenting to you physically violent. Or present a significant risk to others. Illegally permissible if you believe that the patient is a threat to him or himself or others. Consult medical control for authorization. However, in some states, only law enforcement officer can forcibly restrain this patient. Understand your local laws and how to. So the right to refuse treatment. This is one of those things that can get you in the most trouble very quickly. So always document refusals very carefully. Conscious alert adults who appear to have decision-making capacity have their right to refuse treatment. Can withdraw from treatment at any time, even if it results in death or serious injury. So, a lot of times these do put you in some ethical dilemmas You know, should I really let this patient, go home or refuse treatment or anything like that? As long as you can document what's going on, um, that's the most important thing. Calls involving refusal of treatment are commonly litigated. Proceed cautiously. Make sure that the patient understands potential risks, benefits, treatments, and alternatives. In order to refuse treatment, the patient must be alert and oriented to person, place, and time. So they don't need to have any kind of autoimmune status. Don't have any kind of doubt. If you are, questioning this, call law enforcement. Contact your local medical patrol for direction. Try to approach this patient in a calm, sympathetic manner. And sometimes they do, out of your geriatric population, sometimes they refuse because they're fearful and emotional distress due to going into the hospital. And, they're going into the hospital and they never know, they come out. Talk to them about that. So, hopefully. All right, if you are unable to obtain consent, document any assessment findings and care. Know how much time you spent attempting to provide care, report, and patient signature should be witnessed. So find your witness. Sometimes I don't recommend your own partner on them. Get a family member, get a friend. Call somebody, call a neighbor. Over there. Say, look, this is what's going on with this patient. I just need you to say, hey, look, they refuse to go to the hospital with us. It's your sign right here. Know what to do if the patient refuses to sign the release form. If they do, it's really important then to get that witness out there. Make sure your medical director knows and follow your local protocols. So, a lot of times with refusals, you have to get down to that very thought of, hey, look, if you don't go to the hospital right now, it's a possibility next time we come back out here, somebody's going to found you passed or dead. And make sure you document that you told them that truth. Specify advanced directives, specifies treatment if patient becomes unable to make decisions, leaving wills, DNRs, and organ donation orders. To be valid, it must state the patient's medical problems, have signature of patient or guardian, and have signature of at least one physician. So, DNRs give you that permission not to attempt resuscitation. So a DNR must be valid if it clearly states the patient's medical condition that's signed by the patient or legal guardian. So sometimes, and they've gone away from this, they may have expiration dates. So make sure that that's not there. But a lot of these don't have dates anymore. So even with a DNR, you must provide supportive measures. Give them fluid, drugs that may make them pain-free or something like that, but not drugs that are procedures such as intubations that are going to correct their cardiac support and respiratory support. So patients may have healthcare proxies, doable powers of attorney for healthcare. Only apply if a patient is not capable of making decisions. So, the healthcare proxy is a name surrogate to make decisions for them regarding their healthcare in the event they are incapacitated or unable to make decisions themselves. There are many different types of powers of attorney, and not all authorized medical decision making. Okay, so you may have a power of attorney like, yes, I'm the power of attorney. Okay, but you also have to ask that question: are you a healthcare power of attorney also, or are you a I call it their assets as far as their money power of attorney. So, make sure that if you are presented with power of attorney, paperwork at a medical swing. Contact all medical control for assistance if you have any questions. However, don't delay any emergency medical care while efforts to interpret the power of attorney. So, I'll give you a personal experience with this. I was presented with, power of attorney papers one day, and they were difficult to read, and I didn't quite get all of the language with the legal jargon. So I actually ended up having to call the clerk's office to help get verification of what this paperwork was talking about. The book also talks about physician orders for life-sustaining treatment. An in-life document that emerged in the 1990s, also known as medical orders for life-sustaining treatment. Medical orders on scope of treatment, physician orders on scope of treatment depending on the state and geographic location. So, you're gonna be presented with a lot of different kind of orders, living wills, maybe a lot of different things out there. However, we only follow the BOST forms here in North Carolina and the DNR forms. So just make sure that patients understand that. So they have been provided, with proper advice. All these patients will have a DNR in place. Ethics, ethical principles, and moral obligations. So, ethical responsibilities as a healthcare provider are the responsibilities to yourself, to co-workers, the public, and the patient. Ethics is the philosophy of right and wrong, moral duties, and ideal professional behavior, especially related to actions, conduct, motive, character, and responsibility. So they're associated with what EMS professionals deems right and fitting conduct. Morality is the code of conduct that can be defined by society, religion, or a person, affecting character and conduct and concise. An entire field of ethics known as bioethics has evolved over the past several decades that address issues that arise in the practice of healthcare. So many of these issues have drawn national attention, such as those dealing with the termination of life support, rationing of medical resources, and physician-assisted suicide. So basically, treating a patient ethically means doing so in a manner that conforms to professional standards of conduct and keeps the patient's best interests at the forefront of decision making. So applied ethics refers to the manner in which ethical principles are incorporated into professional conduct. So we can look at Table 3.1 for those guidelines. You must meet your legal and ethical responsibilities by caring for your patient's physical and emotional needs. Practice absolute honesty in reporting. So don't make no false accusations or documentations in your patient care reports. Keeping accurate records, maintain a mastery of skills. Advanced EMTs will encounter ethical dilemmas. So, seek legal advice if you need to. Stay up to date on your skills and information. Confidentiality includes assessment findings, treatment provided, diagnosis, mental and physical condition. If you do release this information, you may be liable for breach of confidentiality. So, make sure that your patient signs a release. This comes into your HIPAA forms. And if you have a legal subpoena. All right. This is usually what we explain to our patients when they sign the HIPAA form. Improper release of confidential information or release of inaccurate information can result in liability. Documenting any objective findings, not personal opinion. You may not agree with what a person's doing. However, don't document your opinion. Just document what was there. HIPAA contains a section on patient privacy. That strengthens privacy laws, provides guidance on what information is protected, responsibilities regarding the protection, and penalties for breaching that protection. All patient information is protected. So this was enacted in 1996. Contains a section on patient privacy that strengthens privacy laws. All patient information that you obtain in the course of providing medical treatment to a patient to be protected health information. So you have the obligations on all protected health information from unwritten disclosure, either written or verbal. It may be disclosed for the purpose of treatment, payment, or operations. So you are permitted to report your assessment findings and treatment to other healthcare providers involved in the care of your patient. But you may also release protected health information to a third-party billing. So just be very careful who you give patient information to. Make sure that it's people involved in the treatment of your patient. Be very careful out in public or even to another provider describing what was going on, especially demographic information. So, I know a lot of us talk about calls sometimes, but we talk about them in general. We had a femur fracture. This is what we did. Try not to give away any of those names. All right, records and reports. Always remember actions not recorded was not performed. So if you didn't write it down, it didn't happen. Incomplete or untidy reports are evidence of incomplete or inexpert emergency care. So mandatory reporting requirements: neglect or abuse of children or older people. So this is things that we have to report to somebody. So we have to either call Adult Protective Services, Department of Social Services, Child Protective Services, law enforcement, somebody. Domestic violence, injury during commission of a felony. Somebody calls you and like, yeah, we're breaking in this house and I cut my hand. I got this big laceration, but law enforcement hasn't been involved. Yeah, you might want to tell that. I was breaking in, I busted the window on his car, and somebody may come up and say, hey, that ain't their car, that belongs to somebody else. Okay? Drug-related injuries, childbirth, rape, animal bites, and certain communicable diseases. Failure to report these. So childbirth is related to occurring outside of a licensed medical facility. So somebody's running a OB clinic and it is not licensed at all. So you may want to report that. So not reporting these may result in disciplinary action, suspension, or privileges to practice as an AEMT. So even a fine or even criminal prosecution. So, you're at the scene of a crime. Notify dispatcher immediately if you believe a crime was committed at the scene. Provide care, but do not disturb the scene more than necessary. This is even more important if you know that you're at the scene of a crime. If there's any chance of attempt resuscitation, and if death is obvious, cover the body, prevent disturbance. Try not to cut holes through your knife or gunshot wounds, or even through the t-shirt. Consider periodically with local authorities and be aware of actions that they want you to take at the scene of a. So, physical signs of death, physician determines cause of death, death is generally defined as absence of circulatory or respiratory function. So, um, so vaccine teams states do not have the authority to pronounce a patient dead if there is any chance that life exists or that the patient can be resuscitated and initiate resuscitative efforts. Death is obvious, no urgent reason exists to move the body. So your immediate action should be to cover the body and prevent any kind of disturbance. Alright, if the body is warm and intact, initiate emergency care. Presumably, signs of death are generally adequate, particularly after severe trauma or long-term illness. Some of these signs of death are maybe cold temperature, hypothermia, emergencies, or crash. Alright, trying to keep up with the slides here. So, presumptive signs of death include lack of pulse, no eye movement, no blood pressure. Cyanosis, and lower body temperature. Definitive signs of decapitation, dependent lividity, and rigor mortis. Okay, in the absence of physician orders, in one case is cold temperature, hypothermia, emergencies are an exception to this rule. In cases of hypothermia, the patient should not be considered dead until he or she is warm or dead. So if the patient's condition is unclear, or if you are unsure whether to initiate care, then it's best to begin CPR immediately and contact medical control for guidance. So, some more definitive signs, of course, a lot of your trauma, especially decapitation. Lividity, which is what you see here in this picture, is on the posterior side, that red color pooling of blood. Rigor mortis is stiffening of the body muscles caused by chemical changes within the muscle itself. It does develop first in the face and the jaw, and then it gradually goes down. And a lot of times we see this in the extremities. So, rate of onset affected by the body's loss of heat to its surroundings usually occurs between 2 and 12 hours after death. So, medical examiner case. Medical examiner must be notified in cases of dead at a scene, unknown cause of death, suicide, violent death, or death from an accident, poisoning, suspicion of criminal act, and death of an infant or child. Okay. When a medical examiner or coroner assumes responsibility for the scene, that responsibility supersedes all others. So technically, the medical examiner, especially in the state of North Carolina, takes over that body. Make every attempt to limit your disturbance of a scene involving a death. Medical examiners do kind of like a investigation of the scene as a whole. There's a lot of questions that have to be asked. So, if the emergency medical care has been initiated, keep thorough notes of what was done, and what was found. So, if you think it's going to be a medical examiner's case, but you need to provide care, please make sure that you document very well the position in which the patient was found, any weapons, medication bottles, or other important objects. Also, anything else relating to the scene that you witnessed. So, organ donorship. You may be called to a scene involving a potential organ donor, but this is a person who has expressed a wish to donate organs. So evidence-based, either by a donor card or a driver's license. You may need to consult with local medical control. Treat organ donors the same as any other patient, and your priority is to save that patient's life. However, do remember that organs need oxygen at all times. Medical identification insignia may be patients carrying important medical information. These things could be anywhere, and don't forget about your phones nowadays. A lot of times you can play with an iPhone and that emergency medical care stuff on the iPhone on the phone too, especially when you hit the emergency button. So, may include the in order whether the patient has allergies, diabetes, epilepsy, or some other serious condition. So be sure to check any jewelry a patient may be wearing because identification comes in many different forms. All right, and that is Chapter 3. Still going criminal penalties. If a patient is responsible in a situation is not urgent, consent is required. So your service will have, clearly defined protocols pertaining to these situations. So, however, after the restraints are applied, do not, I wouldn't advise you to remove them en route, even if that patient is promised to act calmly. You need to monitor these patients closely for signs of difficulty breathing. So, understand your local protocols and policies as far as forcibly restraining a patient. Sometimes it is necessary, and sometimes it can be a long and drawn out process. Telephone radio. That's your online medical direction. So your offline medical direction is your standard orders and your protocols and what you follow on a day-to-day basis. So please be very careful when you do online. I always try to iterate to people, please repeat back what they said to you. If you do have a question about it, make sure that you and whoever the providers you're talking to are on the same page and you both understand the consequences of your actions. So, and also, that medical director advises you to do something. Make sure that you agree to it. So, carrying out procedures outside the scope of practice may be considered negligent. It may also be a criminal offense in some states. So, the most important thing is trying to treat all your patients in a kind of professional manner, the way that you would like your own family to be treated. So, treat everybody like you would want your own parents to be treated or your own children, so that you're able to go home at night and lay your head down in peace. So, you and your EMS providers have a legal responsibility to provide proper and consistent patient care and to report problems to your medical director immediately. And the best thing about that is always can be upfront and honest. If you make a mistake or something goes south and you don't quite understand why it did, at least you're starting to correct the process besides it coming after you later.